right now, today. If something happened to you tonight, your family could not touch a single dollar in your bank account. Not tomorrow, not next week. A will wouldn't help them. A notarized estate plan wouldn't help them. Even hiring an attorney after the fact wouldn't help them. There's one form completely free, takes about 10 minutes that bypasses all of it. And the reason almost nobody's heard of it is simple. Nobody whose job depends on the current system has any reason to bring it up. I'm going to show you exactly why your will doesn't control your bank account the way you think it does. Walk you through a real situation where doing everything right still wasn't enough, and give you the one form that fixes it completely. Here's the part that surprises almost everyone. Your will controls your furniture, your car, your jewelry, the physical things in your home. It does not control your bank account. Banks operate on a completely separate legal track, built around something called the Uniform Probate Code, adopted in some form by every state in the country. Under that framework, your bank account is treated as a contract between you and the bank, and the form on file with that contract is what determines where your money goes, not your will, not your trust, the form on file. If there's no named beneficiary on that form when you pass, the account doesn't go to your family directly. It goes to your estate. And the moment that happens, probate kicks in automatically, whether anyone wanted it to or not. Probate is the court supervised process of validating your will and distributing what's left through the legal system. Most states trigger it once an account passes somewhere between $50,000 and $100,000, a number a lot of retirees cross without realizing it. And probate isn't fast. Most states build in a mandatory waiting period of 3 to 6 months just to give potential creditors time to come forward. Your family can't receive a dollar until that window closes, no matter how clean your finances were. Meanwhile, the funeral bill doesn't wait for the court schedule. Let me show you exactly how this plays out, because the woman in this story did everything people are told to do. Dorothy was 71, a retired school teacher in Illinois. She sold the family home, walked into her bank with $350,000 from the sale, and opened a savings account. She paid an estate attorney $800 for a proper will signed, witnessed, notarized, naming her two adult children, Michael and Sarah, as equal beneficiaries. She put the will in a lockbox and told her son everything was handled. It wasn't. Dorothy passed away from a stroke. Michael and Sarah flew in, received an $11,500 funeral bill, and brought the death certificate and the notarized will straight to the bank. The branch manager looked at both documents and slid them back across the counter. Dorothy had never filed a beneficiary designation on the account itself. Her name was the only one on it. Because the balance was well above the state's threshold, the bank had no legal authority to release a single dollar, even with a valid will in hand. A will is a letter of instruction to a probate judge. It carries no weight at a bank counter. Michael and Sarah put the funeral bill on their own credit cards at interest rates running above 20%, while their mother's $350,000 sat 20 feet away, completely out of reach. Then probate began. A $389 filing fee, a $250 newspaper notice required by Illinois law, a $1,000 executor bond, and an attorney fee that came to over $10,500 on an estate this size. Total time before the family could touch a dollar, 14 months. Total cost and fees alone, over $12,000 on top of the credit card interest that kept accumulating the entire time. Dorothy didn't make a mistake. She did everything she was told to do. The will and the notary simply never reached inside the bank's contract. This same situation has three common entry points, and the fix for all three is identical. The first is simply having no beneficiary on file at all, usually because the account was opened years or decades ago and nobody at the bank ever brought it up. Most estate attorneys draft wills, they don't file bank forms. Those are two completely different documents at two completely different institutions. And almost nobody explains that when you pay for the estate plan. The second and more dangerous is an outdated designation. Maybe you named someone 20 years ago an ex spouse, a parent who's since passed, a sibling you're no longer close with. That name is still on file, and that's who the bank pays, regardless of what your current will says. Courts have ruled on this consistently. The bank looks at the form on file, not the document in your lockbox. The third is the joint ownership assumption. Many couples believe marriage alone means everything automatically passes to the surviving spouse in a lot of states. That's simply not true unless the account is specifically titled that way. And here's the trap hiding inside the most common attempt to fix this: adding an adult child directly as a joint owner. It feels helpful, but the moment you do it, the law treats that money as partly theirs right now while you're still alive. If your child gets sued, divorced, or owes the IRS, your savings can become part of that exposure. The fix is called a payable on death designation, or POD. It's not a will, and it's not a trust. It's a direct instruction to your bank that operates on that exact same contractual track that froze Dorothy's account, which is exactly why it works. The bank never has to consult probate court at all. It just looks at the name on the form. When a valid POD is on file, your beneficiary shows up with a certified death certificate. The bank verifies it, and the transfer happens often within days, sometimes the same day at smaller banks. No judge, no attorney, no waiting period. And unlike adding someone as a joint owner, a POD beneficiary has zero ownership rights while you're alive. Your money stays entirely yours and entirely protected from their creditors until the moment you pass. It costs nothing. Every FDIC insured bank is required to offer it, and there's no fee to file it or maintain it. One important catch: a POD only covers the specific account it's filed on checking, savings, money market. If you have 3 CDs at the same bank, each one needs its own POD filed separately. Brokerage accounts use a related but different form called transfer on death, filed with your brokerage instead of your bank. Retirement accounts like IRAs and 401ks already work this way by federal law, but the name on file is often decades old, and an outdated beneficiary there can override even a current will or divorce decree. And a safe deposit box is its own trap entirely. Banks are required to seal it the moment they're notified of a death, key or no key. If your will is sitting inside it, your family can hit a closed loop. They need the will to open probate, but need a probate order to open the box. The fix there is simple. Add a trusted family member as a joint renter on the box itself while you're alive. Tonight, as things stand, your family still can't touch $1 in your account if something happened unless you filed this form. That's true for most people watching this right now. Go to your bank this week in person or through your online portal and ask specifically for the payable on death beneficiary designation form. If the teller doesn't know what that is, ask for the branch manager. Name a primary beneficiary using their full legal name and social security number, not a nickname, not my children, and name a backup beneficiary too. Then check every account separately, because one form doesn't cover all of them. If you know someone who assumes their will already handles this, it doesn't. Send them this video before they find out the way Dorothy's family did. I'll see you in the next one.